decisive error.
Morning, Mrs. Chair.
Morning, my lords, lady. I appear in this matter with Mr. Allen, and the respondent has the advantage of being represented by my learned friends Mr. Johnson and Miss Leach. This appeal concerns one word and a lot of confusion.
One word and a lot of confusion,
The word is the ordinary English word claim, which the divisional court decided meant claim form, and the confusion arises out of the attempt by the court to apply the decision of the Court of Appeal in Abbott 2.
Divisional court, I think, Mr. Stewart.
I thought it said divisional. If I didn't,
You said Court of Appeal.
Oh, I'm sorry, divisional court. Yes, well, that would be rather bold if I was coming to you in relation to that divisional court. I am going to, unless diverted, make my submissions under 6 brief heads. The first is I'm going to deal quite briefly with what we say the construction of the relevant rules are, and that is essentially dealing with paragraphs 6 to 8 of the submissions in our main skeleton argument. The second, I'm going to deal with some crucial, essential, factual features of the present case, and that is in essence by reference to paragraphs 21 to 28 of our skeleton argument, the main one. I'm then going to say why we say the divisional court in Abbott 2 was wrong as a matter of construction, which is essentially paragraphs 9 to 20 of the submissions in our main argument. I'm then going to deal with why the construction adopted by the divisional court gives rise to unsatisfactory and unpredictable results, or as I earlier said, confusion, which is paragraphs 33 to 40 of our skeleton argument and paragraphs 2 to 6 of our supplemental skeleton. Can I just check that you all have hard copies of the supplemental skeleton?
I have hard copies of nothing, Mr. Stewart, and I don't read paper.
Well,
so if you want to hand me anything on paper, you'll learn pretty quickly to send it electronically.
I shall also learn to phrase my questions rather more appropriately.
Yes.
The only reason
Anyway,
I asked,
yes, we've got the copy. We've got them.
I'm then very briefly going to deal with the provisions of the pre-CPR, and finally I'm going to deal with a couple of aspects of the respondent skeleton. I'm not intending in my opening to deal with the European Court of Human Rights point. I will deal with that as appropriate,
yes,
by way of reply.
Yes. And 6?
Sorry, the pre-CPR was 5, and commenting briefly on some aspects of the respondent skeleton, not pre-CPR, was 6.
Now, can I also invite you to tell us how, in your submission, the regime you argue for fits in with the regime of GLOs and the regime of representative actions, because it does seem to me anyway that there are now 3 regimes that exist in our law for bringing claims together. One is the Abbott regime, one is the GLO regime, and the other is the representative action regime. And there doesn't even, we just need to think, don't we, a little more broadly about how and whether this is all very coherent.
My Lord, I will take up your invitation. I will deal with that.
Under 5, probably.
Well, actually, I'll deal with it by way in my first part in 1, because I was going to make some comments in relation to that anyway, and I will expand upon what we say in paragraph 6 to 8 of our submission.
And also by way of introduction, when you deal with 1, in your argument, you might tell us how it came about that there was this sort of sea change when the CPR was introduced without anybody noticing.
Well,
You don't have to do it now.
no,
but,
well, I will deal with that, if I may, when I deal with the pre-CPR position.
Okay. And just one other thing. Tomorrow morning at 11:45, I have to rise for half an hour, I'm afraid. Which means that we'll go on till 1:30 if we need that time tomorrow.
I'm grateful, my Lord. I perhaps over-optimistically thought we might go short, but if you have to bear the burden of that, that will no doubt be something which we will have to take account of, and no doubt I will.
Let's
see
hope we
whether I'm
can
right
go
or not.
short if we can deal with the issues in the shorter time. Yes, on you go then.
Can I invite you, please, just to turn up paragraphs 6 to 8 of our main skeleton argument. And I will deal, first of all, with the provisions which are there set out. I don't intend to go to either Rule 2.3, which simply defines a claimant as a person who makes a claimant, or to Rule 7.2, which identifies that proceedings are started when the court issues a claim form at the request of the claimant. I will make now the obvious point that the issue of a claim form is an extremely important step in many litigations, but many pieces of litigation. But the most obvious point is that it will normally be the point which, as it were, fixes the time at which the action is brought for the purposes of limitation. And one of the points I will make in due course is that significant uncertainty about whether or not you can or cannot include disparate claims in a single claim form is unfortunate, given the consequences, potential consequences for both sides in relation to that particular matter. Rule 7.3 you will already have seen. A claimant may use a single claim form to start all claims which can be conveniently disposed of in the same proceedings. This is obviously one of the rules to which the Divisional Court paid particular attention. It distinguishes in its terms between a claim form and a claim. It refers to a claimant in singular, and in my submission, by itself, it gives rise to no particular difficulties. If a claimant has, for example, a claim against a solicitor and a claim against a surveyor, which overlap, or so forth, then it will be convenient to dispose of in the same proceedings. And I would also be inclined to accept that if you have a claimant who, for example, sues the same defendant in relation to the same essential issues, it may well be convenient for that claimant to be able to issue one claim form. When we come to it, in my submission, the critical point about claim is that the starting point of the rules is one claimant, one claim. There is the express acceptance that you can have one claimant and more than one claim, which makes perfect sense. And the difficult point of this appeal, if I may say so, comes when one considers whether and to what extent you can extend claim. So, for example, just to flag it up now, if you have an event such as the Grenfell fire tragedy, or an event such as the Putney gas explosion, where one event gives rise to claims for damage to property and for personal injury to a number of different claimants at the same time, in ordinary language it may well be possible to say the claimant's claim is for damages which they suffered as a result of the negligence of the defendants in building, designing, inspecting and so forth Grenfell Tower or whatever it is, and you therefore have, say, 1,000 claimants who are bringing a claim in respect of one matter. Just to follow through, and I'm sure...
But I understand your argument to be that the word claim means, I think I've got it written down here,
Paragraph 7 is where I say what it is.
Do you equate it with cause of action?
I do equate it with course of action.
sorry, paragraph 7
Paragraph 7 of my main skeleton argument, my lord, the natural interpretation of the rules.
is a demand for or entitlement to a remedy. That's not what I'm thinking of.
Oh, I'm sorry.
No, you say the claim is only a claim to relief pursued under a cause of action. You say that at 30C. It's in 19.1. And
Claim to relief pursued under a cause of action. Yes.
well, how can that encompass a claim to relief by hundreds of people injured in Grenfell Tower?
Well, my lord, that was why I was saying that the difficult point arises in relation to claim as to whether or not you can go beyond what we've put here. And I'm just identifying that, and I was about to identify what the arguments are and against in relation to it. But the significant matter, my lord, is that for present purposes it cannot possibly be said that you have a single claim in circumstances where you have no common cause of action at all, where there are no common issues for the claimants of either fact or of law, and at most you may have similarities between factual events. And what I was submitting, if I may, to your lordship, is to say that one can see how there is some difficulty about where claim is in this particular case, and your lordship has observed the difference between what I've just said and the Grenfell Tower incident, but what you have not got is a situation anywhere where you can apply the word singular claim to a desperate factual event.
But we have to know what it actually means, not what it doesn't mean. I mean, you're saying it doesn't mean this case, but then you're actually giving us in your skeleton argument an interpretation which is unbelievably narrow and excludes many, many claims that have been brought.
Well, my lord, that was why I was dealing with the difficulty. You have already got 7.2 allowing a single claimant to bring more, and I was suggesting to your lordships, perhaps I should have done it more expressly as a fallback position, but if you have, the word claim is after all an ordinary English word, it is not defined in the CPR anywhere. It must, in my submission, start from an entitlement to relief, that whether it can be said to be an entitlement to relief arising out of a single event such as Grenfell, where there will be binding issues of law, in fact, for example, whether a duty of care is owed to the claimants, whether or not the defendants were negligent, whether or not the consequences of the defendant's negligence was the fire, and so forth.
Well, you say in paragraph 29 that it means a claim to relief pursuant to a cause of action.
I do, my lord.
Well, that's one cause of action.
My lord, yes.
So, I mean, that's unbelievably narrow and balances out Grenfell Tower and Mariana and all the hundreds of cases that have taken place where there have been multiple causes of action by multiple claimants, all in the same case.
But, my lord, it does. I accept that.
So, I mean, it's absolutely revolutionary, your submission.
Well, my lord, it is, but so equally, if I may say so.
Well, it's a cheerful smile, Mr. Stewart, but it's we would be... I'm head of civil justice, you know, I have a sort of interest in this.
My lord, I think everyone has an interest in it.
Yeah.
It's,
No.
I'm not
It's not a
disparaging.
coincidence I'm sitting here, is the point I'm making to you.
But at what level of generality are you referring to a cause of action? In the Grenfell Tower scenario, the individual tenants of the individual flats may have the same cause of action if what you're talking about is a legal structure, but they're different individuals.
Yes.
Is that a cause of action in your terminology, or is that multiple causes of action? They're all the same legally, but they're brought by different people.
So the answer must be that in strict legal terminology, they are all separate causes of action, but they can properly be described as claims arising out of a single wrong, the tort, the necessary tort being the obligation.
Sorry, there can be a claim arising out of a single...
Legal wrong, the tortious event being in that case, negligently building or inspecting, depending on which of the defendants you are that you're looking at, which causes damage to property and persons.
Single transaction or series of transactions.
Well, yes, that would be one way of looking at it. It is to be distinguished in my submission from a situation where, as in this case, we'll just look at the precise facts in a couple of minutes, you have got multiple different contracts entered into at different times where, in relation to different developments...
Why is that not a series of transactions?
Well,
if that's the test, which it's not.
Well, my lord, with respect, the idea that you've got a series of transactions, you can't describe what occurs as a result of 134, it's rather fewer than that, we'll come to it, but thereabouts, individual contracts, individual so forth, as being one claim at all. It's just not possible to do so.
No.
My lord, can I just draw to your attention the points which I'm sure you've got on board, that 16.21 says the claim form must contain a concise statement of the nature of the claim, specify the remedy which it seeks. 16.3 includes requirements as to what the claimant must state in particular forms of claim. And then we get to 19.1. And could I ask you, for these purposes, just to have in front of you CPR Rule 19, my core submission...
Is it in the authorities bundle?
CPR Rule 19 is in the authorities bundle. It is at... page 3 and following. Tab 2, page 3 of the authorities bundle.
Yeah.
Now, the core submission I'm making before I make it good is that the term claim or claims throughout CPR 19 is used in contradistinction to claim form and proceedings. In other words, this is not a case where CPR 19, as it were, uses any of them interchangeably. It understands what they are and refers to them distinctly. So if one looks at 19.1, which is our core rule, any number of claimants or defendants may be joined as parties to a claim. Just making the obvious point, there is nothing here identifying or restricting this rule back by reference to Rule 7. In other words, this isn't saying subject to Rule 7 or anything of that nature. On the face of it, it is an open statement in very wide terms. Then in 19.2
So what do you say the word claim means in 19.1?
I say that it means an entitlement to relief, and my primary position is set out is that means a cause of action. The fallback.
Sorry, your primary position is what?
A cause of action, my lord, as I've said in the passage which I referred to in the skeleton at 7, demand for an entitlement to a remedy, and your lordship referred to at paragraph
30C.
30C.
So, you say now it means an entitlement to relief.
Yes.
May be joined as parties to an entitlement for relief. That
Yes.
doesn't quite work, does it?
Sorry, my lord, I didn't hear you.
So, it doesn't work to say that the rule is to be read as if it said any number of claimants or defendants may be joined as parties to an entitlement to relief. So what are the words that we put in square brackets instead of a claim to make it make sense on your construction?
On the alternative construction I'm putting forward, my lord, any number of claimants or defendants may be joined as parties to a demand for relief. And can I just say why that, in my submission, works? The demand has got to be out of the same piece of relief. It's got to be out of the same event. It's got to be out of the same fundamental legal wrong. It's got to be out of a breach of trust or a breach of contract or a tortious event. Lord, could I just make good the point I was making about the difference between claim and claim form in these proceedings? 19.2 little a, you see the first use, the court may order a person to be added a new party if it's desirable so the court can resolve all matters in dispute in the proceedings. You see in the proceedings also being used in 2b. You see in the proceedings being used in 2.3, and in 19.4 little, 19.3 is actually a matter of some importance because it deals with the position of joint claimants. And it makes the point essentially that they've either got to be joined or they can become parties as defendants, and that's a provision of long standing. And then 19.41, the court's permission is required to remove, add or substitute a party unless the claim form has not been served. 19.44, nobody may be added or substituted as a party unless B, that consent in the proposed amended claim form and particulars of claim have been put forward. And then 19.47, you again have in the proceedings, and 19.49 again in the proceedings, and in 19.49 you've also got a reference to amended claim form. 19.411 is again a party to the proceedings.
So why does this help? I mean, obviously this rule uses the word proceedings, claim form and claim.
Well, exactly. But the decision in Abbott, which was expressed by the court to give rise to some infelicitous language, is that you can substitute for the words claim form. And they are therefore treating, or they were therefore treating, claim and claim form as being synonymous. And my point at the moment is that that is not the case in the rule as a whole. And if they'd intended to say claim form, There is no reason why they wouldn't have said it. That's the only point that I'm making at the moment, my lord. And actually, the misuse of that word, if you had had the word in 19.1 claim form, so you had in 19.1, any number of claimants or defendants may be joined as parties to a claim form. On the face of it, that is an extraordinary rule to put forward. It has no limitations in it whatsoever, and there's no, as it were, guidance in the rules that you have to go back to 7.2. And even if you do go back to 7.2, sorry, 7.3. Sorry, 7.3. All you've got is a claimant may use a single claim form to start all claims which can be conveniently disposed of in the same proceedings.
But a claimant must mean all claimants, must it not?
Yes, but that, with respect, becomes rather circular. I mean, I
mean, you accept it does. I mean, under the Interpretation Act.
Yeah, I do accept it does, yes. But if the point is then being made, a claimant or claimants may use a single claim to bring all proceedings which can be disposed of, but you then say, you interpret 19.1, any number of claimants or defendants may be joined as parties to a claim, you are, with respect, going round in circles about the width of the description. And what you have not got is any kind of express recognition of any kind of links or fallbacks or otherwise determination.
I mean, why should we not hold that claimants may use a single claim form to start all claims which can be conveniently disposed of in the same proceeding?
Well, for two reasons. That's not what the rule says. And
yes, it is. Under the Interpretation Act, it says a claimant or claimants may use a single claim form to start all claims which can be conveniently disposed of in the same proceedings.
Sorry, my lord, I was misunderstanding your question. If you say a claimant or claimants may use a single claim form to start all convenient claims which may be in the same proceedings, that's fine. But where do you then get the entitlement that you can have any number of claimants in proceedings, unless, going back to 19.1, you say any number of claimants or defendants may be joined as parties to a claim. Now, with respect to the Interpretation Act point, the Interpretation Act is obviously dependent upon the context. To say any number of claimants or defendants may be joined as parties to a claim or claims really does, in my submission, make no sense at all.
Well, that's not what I put to you.
No, I know you didn't, my lord, and I misheard what you said. But
no, what I put to you is if a claimant can mean claimants, which you accepted, and I have noted you accept.
Yes.
Then the rule does allow claimants, plural, to use a single claim form to start all claims which can be conveniently disposed of in the same proceedings, without limitation. And so where do you get the limitation which says you cannot? And the only limitation you get is from 19.1.
Well, that with respect then means that if you're looking at if you start with the proposition, which in my submission is correct, that the starting point is you have a single claimant. And these rules aren't against a backdrop of nothing at all. There are the well-known provisions, for example, that you have to have, absent leave of the court, the same set of solicitors and counsel acting for claimants. And the reason for that is that the courts do not want to have 5 different parties.
Where does that rule come from?
Sorry?
The same solicitors and counsel rule?
It's in the notes to the White...
Lewison Daily Telegraph.
Lewis.
It's Lewis and the Daily Telegraph.
Yes, that's it. That is the answer. Is it still Lewis and the Daily Telegraph?
It's still Lewis and the Daily Telegraph.
Have we got that in the bundle?
We haven't got Lewis and the Daily Telegraph in the bundle, but we can get it for you, my lord.
I mean, you know, Mr. Stewart, I have history in this. I declare openly. I started the Gooder-Walker proceedings in 1989 or 90 with 600 claimants, all bringing separate claims against managing agents and members' agents.
At Lloyd's.
Before the GLO process started, and as one of the first, a series of Lloyd's actions. Right? There was Ashworth before that, but this was the sort of biggest one. And at that time, the rules of the Supreme Court applied.
Yes.
And nobody ever suggested we couldn't bring those proceedings, as I recall, but applications were made to the court for management of those proceedings under a sort of pseudo, if I remember correctly, and I'd be corrected if I'm wrong, under a pseudo sort of Beddoes application as to how those proceedings should be managed internally. But it was never suggested you couldn't bring them, even though they were all separate causes of action. Now, if you're right, that changed and ceased to be allowed when these rules were introduced in 1999.
Well, so far as so 2 points in relation to that are concerned. The relevant rules in 1988 are...
I think it was 1990 probably, but yeah.
Are those which are at paragraph, subparagraph 42G of our submissions on page 20 of the...
Yes.
Those are the relevant. Those were the relevant provisions as at.
Sorry, which paragraph of your skeleton did you say?
It's subparagraph F at the very top of page 20, my lord.
Don't give me page. Yeah, okay. Very top.
Sorry, subparagraph 42F. It's page 20 of. I'm afraid I'm working with a hard copy. I hope
It's also 20 on the electronic.
Thank you.
Of your skeleton.
Of our skeleton.
Which paragraph in your skeleton?
Subparagraph F at the top of page 20.
Is that the bundle reference, page 20? Because your skeleton's only 19 pages.
It's the bundle reference.
I'm not using the bundle. Could I
I'm
have
sorry.
it in the paragraph number of your skeleton?
It's paragraph, my lord. 42 subparagraph F.
Thank you. Got that. Right. The rules of the Supreme Court were then amended so as to import the provision law. And that was the rule then, yes, the one that was enacted in 1900 or something like that. All persons may be joined in one action as plaintiffs in whom any right to relief in respect of or arising out of the same transaction or series of transactions is alleged to exist.
That's right.
Where there's a common question of law or fact, which of course there was in the Lloyd's actions.
My lord, absolutely. But can I just identify?
So you say it all changed, yeah?
I do, my lord. But can I just make the point? It's all change on either view in relation to this, because on this, what you've got to have is first of all, the requirements are the same transaction,
yeah,
or series of transactions. Jointly, severally, or the alternative. Where if they brought separate actions, there would be a common question of law or fact. And just applying that, what that means is that you have got an issue, at least one issue, which will be binding. Now, taking the Gooder-Walker shenanigans, as I understand it, and my memory is a little bit hazy in relation to Gooder-Walker, but as I understand it, the actions which were brought against the members and the managing agents at Lloyd's involved saying that they had acted wrongfully in effectively investing within the syndicates, which...
Well, in managing the syndicates, the way they underwrote, yes.
And they did that pursuant to common form members' agent agreements and common form managing agents agreements.
Well, yes, but the advice given to each name was different.
And one of the common issues then arose in relation to that was in relation to the conduct of Good or Walker in running the relevant syndicates. In other words, whether they...
I mean, you're right as to most of it. I mean, that's not this case. I mean, I completely accept that. But, and there were massive numbers of common issues of fact and law.
Absolutely.
Completely agree. But there were also individuals.
Well, I'm not for a minute challenged in prospect that in Good or Walker there were some individual issues. And equally, for the avoidance of any doubt, of course I accept that if you take something like the Grenfell fire tragedy, you will have very substantial issues of common issues, but there will obviously be some individual issues. I mean, most obviously...
Well, like how much damage they suffered.
I mean, more fundamentally, possibly, were they actually at the fire at all?
Yeah, sure.
So, I mean, you're plainly going to have them, but what you will have as a core substrata, at the very least, is, in my submission, something which you can say all these people are making a single claim. Now,
what you're effectively saying is that under the RSC, there was a threshold question, and that was whether any common question of law or fact would arise. And if you can't surmount that threshold, then you couldn't bring a single action.
Yes, and there were, in fact, two thresholds, my lord, the rising out of the same transaction or series of transactions.
But those have disappeared.
Those rules have disappeared, yes, my lord.
Yes.
But does it really then mean that what you are then saying is that you can have any number of claims being added to any claim form subject only to Rule 7.3, which is the alternative position?
I mean, I would get all that if your construction of the word a claim, which is very narrow indeed, allowed Good or Walker. But I'm not sure it does.
Well, my lord, my lord, look.
I mean, not just Good or Walker, but hundreds of claims. Mariana.
Let's, as it were, talk real politics here.
Yes.
My construction in my skeleton, as you have demonstrated, is too narrow for the purposes which are being put forward. And it's probably easier that I get that out of the way now.
Yes.
And start retreating to a rather more defensible ditch. However, we are still looking, in my submission, at whether it can be, the claims can be described as a single claim, and I don't accept, for the avoidance of doubt, that the Interpretation Act could apply to expand claim to claims in 19.1. And then the question, my submission, is can you say, as a matter of ordinary English usage and language, these people are all bringing a single claim? Now, to a lawyer, they'd say, well, they've got, in one sense, a single claim, because they're all claiming as a result of Grenfell, or as a result of the actions. I've forgotten Mr. Good or Walker's first name. It's been some time. But
Derek Walker.
Derek, thank you. But they're all bringing a claim as a result of his activities, and that's how they're being put forward. And you could use that as an ordinary English word. You couldn't, I mean, I'll come on to why I say this, but you couldn't do that in my submission, either in Abbott or in our case. And one reason you couldn't is that on analysis, as we will see from Abbott 3, but also in my submission when one looks at the facts of our case, there simply are no common issues. There is not any common substratum which goes across these events.
I mean, I get all that, and I completely see your factual argument, which, by the way, I don't think you've got the right to argue But what I don't see at the moment is tell me what the defensible ditch is
Right.
for the meaning of the word a claim.
The defensible ditch is a claim, a demand, or an assertion of a right. Probably assertion of a right is better. To relief. Arising out of a common event, and I think I'd have to accept, or series of linked events. And just to be clear why I say that's defensible, it's because in ordinary English language you could describe that as being a claim made by multiple people. You can't describe a claim being made by multiple people which has no common
So would you accept rights to relief? So a claim is the assertion of rights to relief, right or rights?
Yes, I would, my lord, I would.
Yes.
Yes, I would accept that.
So right or rights to relief arising out of a common event or series of linked events.
Yes.
So your submission to us is that the law did not really change
Yes.
when the CPR came in, and that's why you've given us all the Wolf reports, none of which say the law's going to change here.
Exactly, my lord. Exactly.
I mean, that would be nice to think, but it did really change, didn't it? Because of 7.3, which introduced the concept of all claims which can be conveniently disposed of in the same proceeding.
Well, except that in relation to 7.3, that's only a claimant being able to use a single claim form to start all claims which can be conveniently disposed of in the same proceedings. And without wanting to repeat myself, by itself, in my submission, you would not use that to say, well, any number of claimants can bring any number of claims under the same set of proceedings. And the word conveniently, in my submission, is something of a red flag in this context, because, frankly, the idea that at the stage of a claim form, when you haven't even got particulars of claim, you've only got the I was going to say generally endorsed writ, sorry, the claim form itself with general details of the claim, you really know very little about it at all. It's going to be extraordinarily difficult for anyone to come to a sensible position at that point. And in my submission, that's a pointer in favour of giving that rule a restricted interpretation.
Can I just understand that a little better? Because I think you accepted earlier that under the Interpretation Act, claimant includes claimants in 7.3. So on the face of it, you don't need to look further than 7.3, and you say claimants may use a single claim form. Are you saying that you should narrow the interpretation of 7.3 in the context of 19.1 as you interpret it? Is that how you put it?
Well, in my submission, if you look at the rules, sorry, I'm going to answer your question. The answer is not quite, and I will. If you just look at where one starts, a claimant is defined as a person who makes a claim. I accept that the Interpretation Act means that where the single means the plural, you can take it to have that consequence. But if that's going to mean that 7.3 is any number of claimants may use a single claim form to start all claims which can be conveniently disposed of, in my submission is actually quite a strong contraindication. Single claim form and single claimant doesn't look like multiple claimants and multiple and single claim form.
What, just because it's a lot?
Well, because the consequences of doing that are, against the backdrop of which any reader of the rule is going to be so extraordinary. The idea that any number of claimants can use a single claim form, subject only to the test of convenient disposal, is in my submission a surprising one.
Well, it may be a surprising rule, but it is the rule.
Well, my lord, the reason, just to be clear as to why it's a surprising rule, the whole code, that this is the starting point of the start of most civil justice proceedings, leaving Part 8 to one side. You then have rules which apply in terms of what has to go into the claim form, what the defence is, and so forth. The idea that by one, as it were, fairly short rule, all of that goes out and you simply say, well, we've got one claim form, we've got thousands of claimants, and that's it. The only test is convenience, where we can't actually judge convenience at the stage at which the claim form is issued, is in my submission a strong contrary indication. Putting it in terms of contractual construction, and I accept that this isn't a contract. You've got to look at the rules and you've got to look at the commercial consequences, and the commercial consequences would be fairly extraordinary.
Looking at Rule 7.3 just on its own, you've got a claimant with the indefinite article, which I think you accept does admit of an Interpretation Act interpretation. Yes. And then you've got a single claim form, which plainly doesn't admit.
No, well, I agree about that.
Of that interpretation. Single means single, doesn't mean more than one.
No, of course that's right. I mean, you couldn't use the Interpretation Act to say single means two. No, that's I do agree with. But you have then got, as the second part of the sentence, to start all claims which can be conveniently disposed of in the same proceedings. So if you're thinking about what this is actually talking about, and going back to this question, does it mean one claimant or numerous claimants? In my submission, everything is pointing to one claimant can use one claim form to start more than one claim, provided they can be conveniently disposed of. And that's the reason for single. It's making the
Sorry, but then I think you shouldn't be accepting the Interpretation Act point, because the Interpretation Act applies unless the context otherwise requires.
That's what
I think you're saying the context.
that was what I was trying to answer. Okay.
Okay, so you actually do say it should be interpreted as a single
Yes.
claimant.
So you're going back on the acceptance
I am
of my question
Yes.
earlier. Okay.
I wonder, Mr. Stewart, whether your real complaint about Abbott is it gave too broad a meaning to the word conveniently.
In other words, this case isn't about one word, it's about two. Well, we'll come on to it, if I may, in a little bit. But certainly there are diametrically opposed statements as to what the Court of Appeal meant in Abbott, in frankly, in Abbott 2, Abbott 3, and in the County Court decision concerning the leasehold Act. So certainly it is, but the point I'm on at the moment is that convenience is a very odd test at the point at which you're starting, if you're going to apply it to any number of claimants. I am going to move, unless the court has other questions at the moment, to part 2 of my submissions, which is just to identify some particular factual features of this case. And I'm going to do so primarily by reference to what we say in paragraphs 21 to 28 of our submissions. And could I ask you to have to hand the schedule to our supplemental skeleton, which contains a list of all of the claimants, together with the claims which were made in relation to it. It was served with our stock supplemental status. And the points I'm going to make, and I'm going to take you just to a couple of documents to illustrate it, are these. First of all, there are 134 claimants. That could be said to be a slightly misleading number, in that some of the claimants claim in claim jointly. So, for example, if you see claimant number 4, which is Robert Jones and Martine Paul Leigh Jones, I assume is his wife, they entered into 3 property transactions, but they did so jointly. And plainly, there's no issue about joint retainers and so forth. Secondly, just by way of numbers, there are in fact 136 individual purchases of property. And the reason, as it were, for that is that if you look at, for example, number 17, which is Aaron Agarwal and Rita Agarwal and Asha Agarwal and over the page Veena Kumari Agarwal entered into a total of 5 different transactions. As it happens, those were all transactions at the Affa Valley, and if we just look for these purposes in the core bundle at page 274, it's the second core bundle for those who are working in a hard copy, and I hope it's the same page for my lord.
Yeah.
You will see that in relation to these claimants, there's pleaded out a particular unit on page 274, ALP 51, a particular retainer on the 26th of June, the date of the report on the 27th of June. And then can I just ask you to note the version of the report received by the claimant, which is number 3. There were in fact 14 different versions of reports on title in the Afan Valley case. The Afan Valley is the biggest of the developments. These particular claimants, if you look then at 275, you will see that the retainer letter in relation to their second property is the same date as is the date of the report. And so what you have got in this case is the 4 Agarwals buying 5 different properties, but all with the retainer letter on the same date and the report on title on the same date. Now, there is not a unit.
Right? 274 says they got the report the day after the retainer.
Yes, and if you look at the second one, the retainer is also the 26th of June, and the report is also the day after, the 27th of June. And unless I've misread it, I think that's the same for each of these units. Now, that is not a universal position in relation to claimants who bought more than one unit. There are some claimants who bought a unit in one development and a unit in another development and entered into separate retainers. But I'm just explaining the as it were, differences between them. Can we just look at the first claimant in number on page 1 of this schedule, which is Ryan James Morris? He bought on, he had a retainer letter on the 8th of June of 2017 at 245. The exchange of the lease agreement was the 16th of June of 2017. and the version of the report received by the claimant was version number 1. And if you then would...
So what's the point you're making in
The
showing
point-
us all these facts?
Sorry, the point I'm going to make, my lord, and I'm going to show you in a minute, is that you have got an enormous variety of different asserted dates, different asserted contracts, different units being bought, and different advice being given, even on the claimant's own case, and even in respect of one development, without looking at the 9 developments. And the point that this is going to is that in my submission, on analysis, there is no common issue which has been identified by the claimants.
But you're not appealing on that.
Sorry?
You're not appealing on that.
No, well, my lord, what I'm making the point, though, is that the idea that convenience can lead to this situation is something which, in my submission, would be extremely surprising. It is therefore a point going, if I may, to misuse the language of contractual construction, to the business consequences of one construction as opposed to the other. That's the point it goes to.
I think my lord would say it was contractual interpretation and statutory construction, but anyway.
My lord, can I just make the point that I wish to make in relation to the advice? If you would be kind enough to go to bundle 3 of the core bundle. You will see that at Appendix 3, at page 521,
521.
521, my lord, yes. The claimant, in the appendices to its particulars of claim, summarises what it says is the different relevant advice given to different relevant claimants. And by way of example only, report version 1, which is Mr. Morris, who's claimant number 1, is at 521. And if you look over the page, you will see a report on title which identifies various matters. At the top of the page, the way the agreement works is that it allows Affin Valley Limited to utilise your money straight away. Then there's various other points, and then just by the hole punch, about 2/3 of the way down the page, please remember that whilst the legal structure is fine, the efficacy of this investment is wholly on the basis of the continued solvency of Affin Valley Limited. Your investment is dependent on the continued solvency of Affin Valley, and you may struggle to dispose of the land plot of similar value to a third party in the event they either go bankrupt, abscond, or fail to deliver. By way of contrast and showing you how across even Affin Valley, you've got, if you go to the version of the report on title for report version 14, which is to be found on page 537, you've got Mr. Rogers, who's claimant number 58, and you'll see that the report on title is on a substantially different form. Just about the middle of the page, Affin Valley agrees to grant the lease to you, but it's conditional on the following: the acquisition of the estate, the obtaining of satisfactory planning permission, delivery of the lodge in accordance with the lodge specification, and then there's various other matters set out. And then there's a reference to guarantees, and then on 539, the guarantee and indemnity is the promise from 6 other companies in the same group on the same structure to jointly and severally guarantees SIC to you whenever an obliger doesn't pay. Guaranteed obligations include the deposit only, not for your returns. Guarantee will cover the period between exchange of contracts and completion of buyback. Please see the following link for further information. Please note we're not qualified to advise whether or not these companies are sufficiently healthy to act as robust guarantors or that your funds will not be at risk. So what I am showing you is that on one of the developments, these transactions, which are taking place some considerable time apart, under different retainers to different people, there is plainly materially different advice being given in relation to the risks which are being entered into. There is no common issue in my submission in relation, therefore, to breach. There is no common contract. There can self-evidently be no common issue as to reliance or causation. These claimants will no doubt have to say that despite being given the warnings they were given, if they'd been given other or different warnings, they wouldn't have purchased. The loss claimed is not the same.
Is there not a common issue in that all of them say they weren't told this was or might be a collective investment scheme?
So, my lord, I was just going to come on to that. That is, they do, well, the first point is they are, it's a common claim that in relation to each of the 9 developments, the facts of which are different, they weren't told that it was or might be a collective investment scheme. The self-evidently in my submission, it is not a common issue of either fact or law whether or not Appellant Valley is a collective investment scheme as compared with Foxtrot Developments Limited. So the starting point is on any basis you've got 9 different issues in relation to that. Secondly, the actual issue in each case will be whether or not there was a breach of contract. Well, I suppose one could say this. There could be an issue, which I would accept, I think, would have to be common, that as to whether or not a particular scheme was or was not a collective investment scheme. Because one can see that on the same findings, given that the whole nature of this thing is a collective investment scheme, that actual issue in relation to each one of the 9 ones is probably a common issue.
But that only gets you as far as chopping the action into 9 different actions.
Well, that's the first point. The second point is actually the critical issue in relation to this is still going to be whether or not we acted in breach of contract in relation to that. That issue in my submission, I say breach of contract or negligent, because they rely on both. That issue is not going to be the same, not least because of the time differences. There are one of the factors which is relied on is warnings. Now, in essence,
Is what?
is one of the points which is relied on by the claimants is that there were various SRA statements which, over time, effectively gave warnings as to collective investment schemes. Now, I would accept, my lord, that the collective investment scheme is the closest thing that you've got to a common issue.
But you're not appealing on this, and you're not appealing paragraph 37 of the judge's judgment.
No, well,
There's been the causes of action are identical. There are common issues, including the scope of the defendant's duties arising from the retainer letters, terms of business, and any obligations implied by law.
well, can I just go? Sorry, I didn't mean to interrupt you. Can I just go forward slightly?
Reading it.
I will show you that what the judge's interpretation was in the case which I am appealing, which I say is wrong, as to Abbott, is different in our submission from what Abbott 3 certainly says was the position in Abbott 2. And so at the moment, in my submission, legitimately, I am on the confusion caused by the Abbott decision, that being relevant to the 2 issues for which I have got permission, I am before you, which is as to the correct construction and the effects of that. That's how I put it, Lord. Lord, I've really done what I wanted to do in relation.
Well, I mean, if Abbott lays down the wrong test, and that's the test the judge applied, then even though you haven't got permission separately to appeal against his determination, the consequence of overturning Abbott or modifying Abbott might be that one has to revisit
Well, that would certainly be my submission. We originally had 3 grounds of appeal, and the second ground of appeal was that Abbott got wrong. The third ground was the judge misapplied Abbott. I haven't got permission on that, but that proceeds upon
what
the
I said was if the test in Abbott is correct,
yes,
then I didn't think you had a real prospect.
My Lord, I think we're violently
But if
agree.
the test in Abbott is not correct,
that is certainly my submission, my Lord. And can I put it this way? At the very least, and stepping slightly outside my role as advocate, it would be quite useful to know what the test in Abbott actually is, because, as I say, I shall come on in a minute to show you how it has been differently understood by courts who are doing their best to understand it. That was all on the factual material which I wanted to put forward, but your lordships, I'm sure, got the essential factual background against which this case is being construed. The next part of our submissions is why the divisional court in Abbott was wrong, and the critical part of our submissions in relation to that is paragraphs 9 to 20 of our skeleton argument. Sorry, our main skeleton argument. Now,
So are we going to look at Abbott or not?
my Lord, yes. Could we have Abbott? It's in the first authorities bundle. And it's at tab 2, and it starts at page 6, page 19, I think, of the bundle.
yeah, tab 3 actually.
Yes, I'm sorry, tab 3. Now, your lordships have, I'm sure, got the point that Abbott is not a terribly satisfactory decision from at least this point of view. The Ministry of Defence weren't originally taking a point about the claim form at all. They effectively jumped on the master's bandwagon at first instance. They did then take essentially the point that I'm making about claim, but they abandoned it, it would appear, from the judgments substantially without argument. And if you look at paragraph 1 of Mr. Justice Andrew Baker's decision, you'll see at the end of the paragraph he says the appeal turns principally on CPR 7.3 is very little dispute as regards 19.1. And then if you look and see...
So the meaning of the word claim was not litigated?
No, Model, can I just show you what the relevant parts of that were? He deals with that, if you go in his judgment, perhaps start at 41 on page 29.
It's 44,
Yeah,
really.
yes.
Says claim does not mean cause of action.
Yes. It's also 42. Reading CPR 19.1 with CPR and with the detailed rules that follow in 19.2, substitute the reference to parties being joined as parties to a claim is plainly a reference to a set of proceedings commenced by a plain form. It is not a reference to an individual cause of action or claim for relief. That said, because the word claim can be used to denote something more specific, for example, a particular cause of action, it might be even clearer if 19.1 referred to a claim form or proceedings rather than the claim. Now, with respect to the learned judge, other than by way of assertion, there is no explanation of that part of the decision. And when I took you a few minutes ago to Rule 19, in my submission there is nothing within the rest of Rule 19 to justify the assertion that the reference to parties being joined as parties is plainly a reference to a set of proceedings commenced by a claim form. And that was why I was rather labouring the point about the distinction between proceedings when they wanted to use the word proceedings and claim form when they wanted to use the word claim form. And then, if you look at 44, as my Lord, or Justice Lewison just invited me to do, in the event what I've said so far was not contentious before us, Mr. Platt accepted that contrary to the submissions made to Master Davis and repeated in his skeleton argument, realistically he couldn't suggest that claim meant cause of action. And in my submission, therefore, that's the limit of, as it were, the argument on the point which is currently before your lordships. So far as the result of the test is concerned, if we could just go to paragraph 66 of the judgment, which is at page 35.
Are you going to go back on other parts of this judgment, or are we leaving this part?
I wasn't going to go back after we got to
Well,
this.
I wonder if I could ask you to explain paragraphs 45 and 46. Mr. Platt for the MOD says the claim properly brought pursuant to 7 or 8. That has the test of convenience in mind. And then Mr. Justice Andrew Baker says that he doesn't agree that proceedings commenced by a single claim form are only a single claim if the CPR 7.3 test of convenience is satisfied. And then he goes on to say if it's may be necessary to sever these claims. Well, I must say, speaking for myself, don't understand what he's getting at in that paragraph.
Well, I respectfully agree with my Lord in relation to that. To make the obvious practical point first, you start a claim form, and then if the failure to satisfy that such that just cause required the regulator to react, the offending claims can be removed from the proceedings. Well, there are a number of problems about that. Which are the offending claims and the non-offending claims? In other words, which ones are going to stay in and which ones are going to be left?
Well, the inconvenient ones.
Well, it's I suppose one might say it's which ones. What's the starting point? What's the base? What are you judging the inconvenience by? What's the base one? Which
But, you know, I mean, the problem with all this is that your construction, when you go back to saying it's only a claimant, not claimants, is much narrower than the main submission that you said was your defensible ditch, which is that a claim is the assertion of right or rights to relief arising out of a common event or series of linked events. Because that submission doesn't work with a claimant meaning a claimant. So how do you square this circle? You know, I mean, it seems to me, if I may respectfully say so, that you are driven to saying that the word convenience has a limiting effect. And I think what you're saying is that the word convenience has a limiting effect in exactly the same way as the rules under the CPR were limited. I mean, if you're saying that, for goodness sake, tell us, because it'll be clearer. might help, Mr. Johnson. To know, I mean, not to win.
No, I realise that, my lord. It's 3 points.
3 points. Okay.
1, convenience in the context of 7.3 has to be judged against the context in which it appears. 2, given the consequences of the application of 7.3, there is a need for certainty and clarity about the word convenience. 3, there is no certainty and clarity by a mechanism which cannot be judged by reference to what is known at the time the claim form is going to be issued. Now that is rather a long way of saying that, if necessary, I do respectfully accept your lordship that to go back to convenience, or go back to the test in 19.1 is useful. I don't think it involves me abandoning my position about the width of 19.1. Sorry, I should be, when I said 19, I was meaning 16.1 of these of the original RSC, the part I read for you from subparagraph G of R skeleton.
So you're saying use the old test in 16.1 as a measure of what's convenient?
Well, certainly. I mean, it's expressed as such.
Despite those tests not appearing.
Yes, but that's true. Well, I've made the point, and I won't repeat it, but I will just make it plain. An open-ended, uncertain test in this of all parts of the CPR is about as unsatisfactory as you can imagine from the reasons I put forward.
Which rule was it in the 1999 White Book, 16.1?
I think it was 15.4, my lord.
It was 15.4, okay.
I've still got my 1999 White Book, so I will check that.
So have I, Mr. Stewart. So have I, and it's one of the limited exceptions I make to my rule about paper.
I hope your name is in very large letters on it, my lord.
So 15.4 says, subject to Rule 5.1, 2 or more persons may be joined together in one action as plaintiffs with the leave of the court, or where, if separate actions were brought by or against each of them, as the case may be, some common questions of law or fact would arise in all the actions. And, I mean, some might say that was a very sensible rule. But it's not the rule now, right?
No, but I would respectfully agree. Sometimes say there are some other rules which are quite sensible, but we probably don't need to get into a philosophical discussion.
Well, that concept of common issue of law or fact is there, but it's in the GLO.
Sorry.
It's in the GLO rules. It's the definition of the GLO issue.
Your lordship. Sorry.
That's
right. It is. Can I just deal with?
So are you really saying that the word conveniently shouldn't be applied to a series of individual claims which raise no common issue of fact or law, that really what it comes to?
Well, I'm certainly saying that if necessary, my lord, because I mean, just applying a sort of a prioritas, how can it be
Yeah.
convenient?
And you say the result in Abbott, where 3,000 whatever it is claims have to be individually investigated, as Mr. Justice Jarman and Master Davidson subsequently decided, cannot be described as convenient.
I do, my lord. I am going to take you briefly at some point to the tension which exists in both the judicial statements and with respect to my learned friends in their argument as to whether there does or does not need to be a binding issue of law or not for the purposes of the convenience.
But let's say that Judge Jarman was right in paragraph 37, or the one I read out, to say there were common issues of fact and law in this case. And let's say that there are common issues of fact or law in the Abbott case, even if they are limited, right? Just one about the duty that arises from military activities in relation to people's hearing. That might arise in most of the cases. How does one decide what is convenient? Do you say there has to be one issue, or there have to be enough issues to make it to prevent the need for individual hearings at all? Because actually, as you admit, if cases don't settle, in most cases there is a need for individual assessment of damages. And in the Lloyd and Google case, where we're talking about representative proceedings, I wasn't actually overruled on the subject of whether or not there could be a representative action, just because the damage might be different in each case. So what I'm trying to get to is it seems to me, and I'm only speaking for myself, that we have to apply the current rule.
Well, that I agree with, my lord.
That doesn't seem controversial, but it's sounding a bit controversial.
No, that's...
But then we have to find a meaning for convenience. And your I think, second ditch, if I can put it this way, is that convenience means what it says in 15.4 of the RSC, which is a rather complex way of describing the word convenient, but nonetheless has the great benefit that we would know what it meant in every case. It would have what you'd call, in your submission, clarity and certainty. But how do we get that?
Well, I'm very briefly going to defend the first ditch. The reason why convenient is a different word, a difficult word, is that convenient is, frankly, extremely subjective when looked at. And there is no guidance given in Rule 7.3 expressly as what is meant by convenience.
What do the notes to the CPR say?
So, what the notes to the CPR say on this point, although not on all points, they are, I think, helpful to
Mr. Johnson.
Yes.
Which is it? Is it in the bundle?
The notes, I'm afraid, are not in the bundle. We did have a discussion about how much of the white book we should put in, and I'm afraid rather pusillanimously we got frightened off by the practice direction. But
I think I've only got a 23 white book here, actually, so I can't. I'll look it up online.
The relevant the relevant paragraph is, I think, 7.3.5. The test for joinder is merely whether the several claims can be conveniently disposed of in the same proceedings. In terms, neither the rule nor its related practice direction provides any further test. Many matters may be relevant to the question whether two or more claims can be conveniently disposed of in the same proceedings. It may be inconvenient to attempt to try the claims together. In this event, there's no need to impugn the validity of the initial joinder of claims in the one claim form. Instead, reliance may be placed on the court's powers to order separate trials to mitigate the inconvenience. It may also be inconvenient to attempt to handle two or more claims together throughout or as part of the pre-trial process. If the expression disposed of is given a broad meaning and isn't confined to those steps in the procedural process which will, e.g. a trial, or may, e.g. an application for summary judgment, result in the disposal of the action, but is interpreted as including the pre-trial process generally, additional inconvenience concerns may arise. The court has recently been confronted with an extreme attempts to bring claims on behalf of multiple claimants or to sue multiple defendants in one action. See Abbott against the Ministry of Defence and Thurrock against Scotes. In both cases, the court concluded the convenience process was conclusively failed. That's from 2023 White Book.
That's the reference to Master Davidson's decision.
Yes, that's a reference to the first
division.
instance. No, that's right.
That's not very helpful, really. Okay.
The notes at 7.3.1 give some examples. They say, partway through that, the assumption has been that for a variety of reasons there should be limits. On the whole, constraints on party joinder have been more severe than constraints on claims joinder. They don't tell you where they get that from.
Yes, and they do say, as I'm sure Mr. Johnson would point out, over the years the trend has been towards liberalising the rules restraining joinder and encouraging joinder of the same proceedings for all claims and interested parties. Now, I'm conscious that I'm in breach of promise because I promised to deal with representative proceedings and GLO and forgot to. So I better deal with representative proceedings and GLO. Can I deal first with representative proceedings? And it's probably appropriate that one does this before having a look at Abbott 3, and the starting point is Rule 19.21. A group litigation order means an order made under Rule 19.22 to provide for the case management of claims which give rise to common or related issues of fact or law. So you have, in my submission, got there some support for the idea that claims are being looked at on an individual basis, and in order to get a GLO, you've got to have common or related issues of fact or law. In 19.22, the power is given to the court to make a GLO where there are or likely to be a number of claims giving rise to the GLO issues. The multiple parties may be claimants or defendants. And then one sees the GLO must contain directions about the establishment of a register, the group register on which the claims managed under the GLO will be entered, specify the GLO issues which will identify the claims to be managed as a group, specify the court, etc. And then 3, in relation to claims which raise one or more of the GLO issues, direct their transfer, etc. Now, what you are therefore doing is effectively the court taking control by an identified process at the invitation of one or more parties of a number of different claims in order to deal with common issues of fact or law. It would, in my submission, be very strange if you could have claims which had no common issues of fact or law because they were claims as identified by the divisional court, meaning the claim set out in a claim form on the basis that that's simply defined by convenience, then being subject to the GLO regime. There is, at the very least, in my submission, a substantial tension between those two.
Well, what does the word claim mean in 19.21 and 19.22 sub 1? Because it looks to me as if claim means or implies claims made in different claim forms.
You get a little bit of help to that, sorry, you get a little bit of help in relation to that question, my lord, from the practice direction. Just find the reference to it.
The practice direction.
Practice direction 19B on group litigation, which deals with a group register, and that says once a GLO 6.1 has been made, a group register will be established on which will be entered such details as the court may direct of the cases which are to be subject to the GLO. And then 6.1a, a claim must be issued before it can be entered on a group register. So it does appear, looking at the two together, that you are looking at a claim as made in a claim form, and that before it can be the subject of the group register, it's got to be entered on it, taking those two together.
A claim in a claim form.
Well, 6.1a, I'm making a point against myself, I think. A claim
Yes.
Must be issued before it can be entered on a group register.
It says nothing about who's named as the claimant or claimants on that claim form.
It doesn't.
No, but the point I'm making is that 1921 and 1922 seems to be using the word claim not to mean a cause of action or a claim made in a claim form, but case management of a claim, of claims, brackets, which may be made in multiple claim forms, i.e. falsifying your reference in the earlier part of 19 to a claim not meaning claim form.
Well, my lord, I think I have to accept that when we're looking at 19.22, that's
It does mean, that's what it does mean.
well, that's what it means. I agree.
Yeah.
And my lord,
The GLA will bring together different actions, started at different times, perhaps, provided that they satisfy the threshold test.
it will.
And in paragraph 6.1a of the practice direction, you don't actually issue a claim. You can't issue a claim. You have to issue a claim form.
Yes, you enter the. You effectively have to notify the existence of your right. Well, before I come to representative actions, and I haven't forgotten, can I deal at this point with Abbott 3? Because Abbott 3 is, as it were, dealing with what I say is the tension between Abbott 2 and the GLO procedure.
Yes.
Now, for these purposes, could we have, could you have, please, our supplemental skeleton argument and Abbott 3, which is to be found in tab 4 at pages 43 and following, and the relevant background to this is really summarised by us in paragraphs 2 and following. And what, in essence, happened in Abbott 3 was that the 3,500 claimants who'd been allowed to issue a single claim form in Abbott 2 applied for a GL order, and the effect of that and that's as a consequence of CPR 19.23. It may just be worth having a look at that. Is that the judgment or order in any claim would bind all the parties to all other claims unless the court orders otherwise. It was opposed by 5,000 other claimants who were represented by numerous other firms who didn't wish to join the GLO. And what Mr. Justice Jarman and Master Davison did was at paragraph 10 to record the history of Abbott 2. So at paragraph 10 we get Master Davison's judgment being set out, and then
you get
referred to, sorry, and then one would get to the judgment of
Bacon.
Of the divisional court, and the passages which were set out are paragraph 76 and following, and if we can just look at those in the context at which we're now looking at, this is from Mr. Justice Andrew Baker's judgment. You'll see that Mr. Justice Andrew Baker identifies that Mr. Platt proposed it was likely the findings made upon the trial of the lead claims would be treated by the parties as persuasive. However, he was candid that the formal position that these findings will not be binding in respect of the lead claims are tried. And then one sees Mr. Steinberg didn't accept that. It's not necessary for the disposal of this appeal to resolve that dispute. It suffices to say that the MOD's formal position is not self-evidently wrong, but it couldn't be advanced if the proceedings were still constituted by the omnibus claim form, or if to the like effect the 3,000 separate sets of proceedings now in existence were all consolidated. On the face of things, that would seem to make it convenient, as the claimants have said, for there to be a single action. And then paragraph 77, if the commonality across the claims cohort were very limited, that might not be that convenience after all. In that case, it would be difficult to see why trying lead cases would result in findings that might even have persuasive significance. Then at paragraph 78, you say that you see, taken through the approved list of generic issues in argument, and if one could just scan down those, content of any duty of care during different periods, existence or content of any duty of care during training or overseas, adequacy of protective equipment, etc., suitability or sufficiency of standard diagnostic criteria for noise-induced hearing loss, latency issue, and age-related matters, and asymmetric hearing loss. If you then go to paragraph 49 of Abbott 3, you'll see the court setting out some evidence which was really submissions as to the binding effect of decisions in related cases. And the point being taken effectively was res judicata will bind those cases where a finding of factual law falls within this legal principle in circumstances where the issue is later considered. Then, if there's a GLO, findings of the GLO will bind those cases. Within the enclosure of the GLO, findings of factual law is the meanings of particular provision of the noise regulations are binding. However, the extent to which any such findings are truly binding should not be overstated. Findings of fact are usually case-specific. A finding that serviceman A, who participated in the parachute regiment between 1985 and 1995 in Northern Ireland, has noise-induced hearing loss as a result of exposure, doesn't bind serviceman B, who was deployed with the Green Jackets in Germany and Cyprus between 1990 and 2005. Then practical effect of findings are likely to be influential, and then there's a particular issue about medical liability. And the court then says, in general terms, we agree with that analysis. The outcome of the lead cases would potentially be binding on those named as claimants in the Hugh James military deafness litigation. The doctrine of precedent will apply, most notably an issue is considered in the High Court, not necessary to have a GLO to achieve these outcomes. A GLO would go further and bind the other claimants, but as was pointed out by both the MOD and the opposing parties in argument for us, because the individual claims are so fact sensitive, the lead claims will not in fact be dispositive of either the bulk of the HGS claims or the other claims. And then they refer to a similar position in Durham and Ministry of Defence. And at paragraph 53, they say, we conclude that in circumstances like the present, the fact that judgment in a GL case is binding on all claims caught by that GL, it doesn't weigh heavily in the scales in favour of granting the order. Now, we've described
Which
that.
paragraph is that?
Paragraph 53, my lord.
53. Because there isn't any common issue.
Well, yes. I mean, what we've said in paragraph 3, subparagraph 7 of page 3 of 10 of our supplemental skeleton is that the statement is a little Delphic, but what we understand is essentially what your lordship is saying, that the binding nature of GL order would be illusory where there are so many factual differences between the claims. That appears to be what that's saying.
Well, that's because, isn't it because what they say at 56? The circumstances in which thousands of claimants in the HJS cohort and those who form the opposing parties sustain their injury vary considerably, and they get allegations of breach more diverse.
I agree, my lord.
So in effect they're saying each of these service personnel needs an individual investigation of their particular case. This is how I understand them.
I agree, my lord, and there's some support for that in paragraph 57, where you see that the rule doesn't stipulate the GLO case must be dispositive of the GL claims. That distinction is reflected in the divisional court's decision in this case. They said real progress towards the resolution of the other claims, or real significance, was enough to justify an omnibus claim for. Nevertheless, this remains a highly relevant factor in the decision whether or not to make a GLO. Yeah. If the lead claims will not dispose of the other claims, or a good proportion of them, that diminishes the utility of a GLO.
And then they come back to that at 59. Findings in the lead cases will be dispositive of few, if any. Duplication of effort will not be avoided. The other claims will still need to be thoroughly investigated and presented in detail.
That's right, my lord. They then reject the other reasons at 60 to 63. And in our submissions on this.
What was the threshold issue that they didn't surmount?
I'm sorry,
65. They say we conclude the claimants have failed to make out their case that the threshold requirements are met.
I believe, my lord, that is a reference back to
common or related issues of factual law.
Yes, it's simply a reference to the circumstances in which you can make a GLO at 19.22 and, sorry, 19... Yes, it's essentially give rise to common or related issues of factual law. And one gets that, I think, from
Well, I suppose the question then arises, well, if you've got to investigate each of these claims individually, duplication of effort will not be avoided. Why is it convenient?
Quite so. And that's...
But before we get to that, which obviously is the denouement, the threshold issue, which the judge was talking about in Abbott 3, is under 19.21 that the group litigation order means an order to provide for the case management of claims which give rise to common or related issues of fact and law. I mean, is Mr. Justice Garnham really saying that there were no common issues of related issues of fact or law? Because if he's saying that, then that is actually the reverse of what Abbott 2 decided.
Well, precisely.
Well, I mean, precisely is not good enough. I mean, we need to be absolutely clear about that.
Well, can I show you the part?
Because if we were to accede to your submissions, we're effectively overturning Abbott.
You are, my lord.
And,
Abbott 2.
But they're not here. And they're not here to tell us why we shouldn't. And I know that's not I know that's not an impediment. Is there an appeal from Abbott 2? No.
I don't believe so.
And is there an appeal from Abbott 3?
We don't have any positive information.
But I mean, we will throw Abbott into disarray if we accede to your submissions, right?
Well,
we will throw the case management of Abbott.
well, I mean, just dealing, as it were, with where Abbott has actually got to. If they hadn't appealed and they've gone forward on that basis, they will be bound by their regime therein, just as I forget the case, but it's the case on issue estoppel where the House of Lords comes to a contrary conclusion in relation to the effect, I think, of a rent provision. I'll remind my memory.
Well, I think I'd quite like to hear about that after lunch, if I might.
Arnold and that West Bank.
Is it Arnold? Yes.
Yeah.
It is Arnold.
I think I'd like to see it, please.
Well, we will.
Because if your submission is really going back to Abbott 3, I mean, can you just show me that 65, is actually saying that there are no common issues of fact and law, so they haven't overcome the threshold?
I'm sorry.
Is that what he means in 65?
Well, the relevant section in my submission of Mr. Justice Garland's judgment, which helps in that respect, is paragraphs 13 and following on page 47, which is where he sets out at 19.21, 19.26 and identifies 19.21, and then 19.22. 19.22 provides the court has the discretion to make a GLO. The court may make a GLO where there are or are likely to be a number of claims giving rise to the GLO issues. The multiple parties may be claimants or defendants. Then 15, they must specify the GLO issues which will identify the claims to be managed. And so it's one of the,
Where does he specify the GLO issues alleged?
yes. If you go to threshold criteria, you get help, I think, from 34 and 35.
I think 35 is the closest. Recording submissions.
I agree, my lady. I think that has to be read in the context of 5, where it's being said that the claimants have failed to comply with Practice Direction 19B, which is effectively identifying what the common issues are.
Sorry, which paragraph?
34.
I was looking at 34. My lady had referred to 35, and as she identifies, finally and most importantly, submits the threshold criteria of not being met. He says the court must be satisfied that the claims give rise to a common or related issues of fact or law. He says the resolution of such issues as are listed in the right are not likely to assist in resolving the principal issues in the wide cohort of cases. In my submission, that must be what he's referring to by reference to threshold issues in 60.
Where are those issues in this judgment? The draft GLO?
I don't think they're quoted.
Well, that was why.
I think the court comes back to the point at 57, which you've already shown us. Yeah. So Mr. Platt says that 1921 deals with claims which give rise to common issues, etc. It doesn't stipulate they must be dispositive.
Sorry, the reason I was showing you 34, which on the face of it is something separate, is that what's been done there is no attempt to classify the terms so that in the absence of individual pleading, the court and parties can have ideas as to whether there are issues capable of being determined that might impact on other claims. So in my submission, what is being done here is a combination of threshold means common issues of fact or law, but there's also a complaint that they effectively haven't been set out and specified.
It was highly unsatisfactory. Is it not?
I'm inclined to agree with your lordship in generality, but I'm not sure what you mean.
Well, I mean, it's highly unsatisfactory that, I mean, Abbott too seems to have decided. I mean, I can't remember the bit of Abbott too. I haven't got the very close familiarity you will have with these judgments. But I thought in Abbott too, when Mr. Justice Baker came to apply his test, he said there were common issues.
He said there were common issues, yes, my lord.
Where did he say that?
If you go back to Abbott 1...
Abbott 2.
Sorry,
Page 38, paragraph 78.
Paragraph 78, thank you.
He described them as generic issues rather than common issues, but that may not matter.
So there were content of any duty of care during different periods of time, the existence or content of any duty of care during training or service overseas, the adequacy of standard protective equipment, suitability or sufficiency of standard diagnostic criteria, etc. You've showed us those actually in another context. So the two courts seem to be saying something different.
They do, my lord. And that was where I was essentially heading for in relation to this. And just to pick up the point in our skeleton argument, our supplemental skeleton argument, paragraphs 4 to 6, our submission is the position which the courts are left following Abbott 2 and Abbott 3 is unsatisfactory. It's impossible to discern how it could probably be said that it was convenient for the disparate noise-induced hearing loss claims pursued to be brought under a single claim form, where it wasn't even clear what the true common issues were, or the extent to which any findings in one case would bind any others. And just picking up on the discussion we had about convenience, there can be no proper finding about convenience without forensic and detailed exact approach to an examination of issues which are really common and binding between the different cases. And then you've heard me make about 5 times already the point about the test should be simple and easy to apply.
What is the test that Abbott 2 lays down? At paragraph 70, Mr. Justice Andrew Baker, about halfway through the paragraph, what would make it convenient for there to be one set of proceedings? It would be useful, helpful, highly desirable for significant common issues of fact, and it may be all issues, to be tried in such a way thereafter, in the context of each individual case, the findings made will be binding on both the claimant and the MOD. So this seems to be proposing a test of bindingness of findings.
Yes.
Then at 71, question, he says, is whether the cohort of claims had sufficient commonality and significant issues of fact that were useful or helpful, that any determination of those issues brought against the MOD would be binding also. So he goes again back to binding.
Yes.
And then at 71, subparagraph 4, he then begins to talk about the degree of commonality and the significance for each individual claim of any common issues of fact and law. So he's gone back from binding. And then at 73, he proposes a test of real progress. So I'm not quite sure in my own mind what the test is in Abbott.
Well, it's further, I'm afraid, confused by what Lord Justice Dingemans said. Because if you go
what did he say?
If you go to his judgment, which is at page 41, paragraph 89, the fact that different answers can be given in different sets of proceedings to the question whether claims can be conveniently disposed of is unsurprising. This is because the question is fact specific to the claimants. In Barge and the Ministry of Defence, there were a number of claimants making claims for non-freezing cold injury, which appears to have very little in common. On the other hand, the claims by the 100 or so claimants referred in paragraph 8 appear to have sufficient common features to mean that they would be conveniently disposed of in the same proceeding. So that looks like a test of common features. And then it's apparent the claims can be conveniently disposed of. This is because there are many common issues raised by the claims made by the claimant. These include in particular the question of diagnostic criteria for military non-induced hearing loss. Yes, well, those are the relevant parts.
As well as other matters set out in 78. So
Yes, it goes back to 78.
both judges have said there are these common issues: the existence of contents of duties concerning hearing loss, standard protective equipment. I mean, for example, one can imagine, without making the case up, you can imagine that there would be a case that it was a breach of duty not to provide somebody firing a gun to wear headphones, to wear ear protectors. I mean, I can't imagine there's no such duty, but I'm not deciding that case.
No. Whether there is such a duty in all circumstances, including all the range, is perhaps another matter.
Including?
Well, I mean, taking account of all the varied different circumstances which occur when members of the military fire guns.
So there might be, so for example, you're on duty patrolling Buckingham Palace and there's an intruder and you have to fire a gun.
Yes, I need to be slightly careful because the
No, but I mean, I'm not.
But exactly, you can postulate situations.
You might have to fire a gun.
Yes.
In an emergency.
Yes, quite.
And you might not be wearing ear protectors, right?
And indeed, it might be that the Ministry of Defence would think it's more important that you fired the gun than you put your ear protectors on. Possibly members of the public.
Well, I mean, that's all very interesting. So, but, yeah, okay. I'm not sure where it leaves us, but yes.
Well, I did at least open the second part of my sentence by saying there's a degree of confusion here. But just to pick up where we have got in relation to Abbott and Abbott 2, there is a real question in my submission as what is actually meant by the Abbott test, and in particular whether you need to have common issues which are going to be binding, or whether or not there is merely a test of convenience of some form or another. And just going back to our main skeleton argument.
What did Abbott 3 say that Abbott 2 decided?
I think they went for real progress.
They, in my submission, were strongly in. They were in support of the camp that it wasn't necessary to have binding findings, and sorry,
Paragraph 57.
57. Yes.
They say that the divisional court's decision in this case that real progress or real significance was enough.
Yes, and that's what we've set out in subparagraph 3.9 at the top of page 4 of our skeleton argument.
And what do you say? Do you say that's wrong?
Well, what before sorry, before the judge, I proceeded upon the basis. I reserve the right to say that Abbott was wrong, but we took the position that the test was the court was likely going to be a bold first instance judge who didn't follow the divisional court. We took the position that it was not necessary to have binding issues across it on what the Abbott said. And my friends in this appeal take the opposite position. In the light of, I can show you that if necessary, it's one of the comments I'm going to make on their skeleton, but it's...
What, they say what?
They say that a proper interpretation of Abbott 2 is that you have got to have binding issues. If you can,
I see. It's all right. We don't have to look at it. You say, they say, that Abbott 2 requires binding issues. But what was the position you took below before?
not necessary.
Not necessary to have binding issues.
And the judge, we put that forward as our summation of the test. We, on the basis we were applying to strike out. The judge appears to have proceeded on the basis that was accepted and proceeded on that basis. Can I just show you paragraph 81 of Lord Justice Dingman's speech, because I should have shown you that before at 30, not speech, judgment at 39. Sorry, 91, I was looking at the wrong judgment. Where he says, right at the end of his judgment, it will be for Mr. Justice Garnham and Master Davison to reflect on the submissions made by the Ministry of Defence that findings made in lead claims may not bind other claimants, see paragraph 76, and to take such steps as they see fit to deal with that point.
I mean, if 19.1 and 7.3 only applied, in other words, if convenience only meant that there must be common issues of law and fact that would bind all the parties, then it would be possible to make a GLO in every case where multiple claimants issued the same claim form. I'm not saying the court, as a matter of discretion, would make the GLO, but it would be possible.
I agree with that.
Yeah.
On the premise you put forward.
So on one premise, which is really what I was driving at when I talked about the three regimes, one would imagine the three regimes, I mean, tell me if you think I'm wrong, would cater for different situations.
Well, they certainly cater for overlapping situations which weren't going to be identical. Whether they're exclusive is a different matter.
Well, if every...
No, you're right. Of course, there must be something outside the common area of the Venn diagram, if one can put it that way.
Yeah. Yes. Well, I mean, obviously there would be something outside the common area of the Venn diagram, because there would be just the ordinary case where multiple defendants were sued in the single claim form, and multiple claimants brought the same claim against a single defendant, which wouldn't be possible for a GLO, of course.
No.
But I just... I mean, I'm very troubled by this this apparent inconsistency between Abbott 2 and Abbott 3.
Well, my Lord, I understand that. I mean, you've seen what we've said about it in our supplemental skeleton.
So what do you now say? You say... I mean, you say something really completely different from Abbott 2 and Abbott 3.
We do, my Lord. We stay.
You say convenience means what it used to mean under the CPR, under the RSC, and there we go.
Well, yes, and your Lordship has my submission also about that's obviously under 7.3, but I've also got the point before that.
Yes, you've got the previous 2 points, in fact. You've got 2 ditches.
Yes, although I think the enemy, no, I was going to say the enemy. The troops are overwhelmed, one of them, but anyway. My Lord, representative proceedings.
Yes.
It may be more convenient, my Lord. I think I am going to be going on after the shorter journals. If you don't mind, if I deal with representative proceedings afterwards, because it's
no, because we recently gave a judgment on representative proceedings following Lloyd and Google in a case called something recovery. It's a patent.
Commission recovery.
What's it called? Commission recovery, is it? Were you in it?
No.
I think it may be convenient.
It's a
I will do
decision
it more
of Lord
quickly
Justice
if I do it after the short adjournment.
Yeah, okay.
If that's convenient. I have really dealt with the points that I was making, which were originally under my fourth head, as to why the construction adopted by the Divisional Court gives rise to unsatisfactory and unpredictable results, which I'd identified in paragraphs 33 to 40 of our skeleton and paragraphs 2 to 6 of our supplemental submissions. The one decision which I haven't really taken you to at all is the decision of His Honour Judge Worcester in Stewart, Angel and Black Horse Limited. And we deal with that in our skeleton argument in paragraph 13 through until paragraph 17. And I think I would like to identify briefly what is said in relation to that.
This is not binding on us. I mean, it's not binding even on, it's not even persuasive. It's not a court of record.
No, but it does show the difficulties that the courts are having, which may be of...
That's really the purpose of looking at it, yes.
Maybe of some assistance. My lord. What this was is claims being brought by more than 5,000 claim forms, and there were actually 8 claim forms, one for each of the defendants. And what was being sought was judgments in each case that the relationship between the claimants were unfair within the meaning of section 140A of the Consumer Credit Act. And the first thing that happened is there was an application to transfer the matter to the High Court, and that failed because the County Court has exclusive jurisdiction in relation to Consumer Credit Act matters. If you look at what the judge said at paragraph 19, which is on page 63, he identifies the various parties, and he identifies there are 5,277 claimants, of which 4,577 are the cohorts making claims against Black Horse, VW or BMW. They're all represented by the same solicitors, and I can assume they'll make common cause. But whilst they may all seek release of the same nature, they're not jointly entitled to a remedy. They bring individual claims. As yet, no defences have been filed. Then he recites submissions, including referring to the decision of His Honour Judge Waxman, as he then was, and Harrison and Black Horse, making the point that effectively these are individual cases, and then referred to the judgment of Lord Sumption in Pleven and Paragram at 121.
They were manifestly different.
Quite so.
Facts are manifestly different.
Quite so.
Yeah.
And the obvious point is that a finding in one case about an unfair relationship wouldn't give rise to a binding precedent. The relationship between the other claimants and the same defendant was unfair, and that you get that expressly at 36 and 42. For what it is worth, we do say that is directly analogous. It's well established that the advice that you need to give as a solicitor may vary according to the nature of your client. It doesn't follow at all that because one client does or does not need advice, another client does or does not need advice. And your lordships have already seen that in relation to one set of transactions alone, there are 14 different reports on title. I haven't shown you, but it's in the pleadings.
Sorry, have we finished with Judge
No,
Wilson?
not quite, my lord.
No.
Then paragraph 33, can you look at, please? And this is where he's considering the decision in the divisional court, paragraphs 31 and following. And at 31, he recites fairly well known by now to us parts of the judgment, particularly from Mr. Justice Andrew Baker. And then he says in paragraph 33, the first issue is considered as whether there is sufficient commonality of significant issues between the claims brought by the same claim form that it would be useful or helpful to determine those issues within the one set of proceedings. The second is whether that determination would be binding on the other proceedings. If you look at paragraph 41, he's dealing with the first of those two issues.
But why is that second issue arising from the decision of Andrew Baker? I mean, he decided something the reverse of that. He decided you needed to have real progress, or you needed to have some other words.
Well, I mean, that raises the issue as to what the true test was in relation to
So he's applying a quite different test.
that's the point I'm making.
Yeah, okay, good.
That's the point. But he's purporting to do so, having looked at the decision of the divisional court.
He didn't understand. Yes, okay. Well, he might be right.
Yes. And if you look at paragraph 41 of his judgment, you'll see that he refers to the decision of Andrew Baker in paragraph 70. He submits that the judge's approach is premised on the assumption that if there are common issues determined to claim, the court's finding of those issues binds the defendant in respect to the claims made by the co-claimants. I'm not entirely convinced that's correct, at least without it being left to the discretion to that effect given to the court. And then he refers to the passage from Lord Justice Bingaman's that we just looked at right at the end of the judgment at paragraph 91. But assuming that it is, or the court makes a direction to that effect, a binding judgment on the two common issues Mr. Clark puts forward has a limited effect because the general in principle nature of a decision on the issues he proposes and because of the fact-specific nature of a section 140 claim. And then at 44, he comes back and says the central issue is whether there are significant common issues, the determinant of which would amount to real progress towards the final determination of each set of claims. I agree with Mr. Clark, this is not the number of matters which matter, but their significance and commonality, and he's satisfied that that is not the case.
So in the end, he applies the real progress test.
He does, my lord.
Right.
And the only other parts to identify is that in that case, my understanding, incidentally, is that the judge has granted permission to appeal in relation to this judgment, and you, my lord, the Master Rolls, gave permission for the skeleton arguments to be provided to the parties in that case, a fact which you may possibly have forgotten. But,
So I gave permission, of course I have instant recall. Just remind me what I did.
you simply allowed the skeleton arguments in this case to be provided to the parties
In Abbott.
In
Angel.
One of the points you made earlier, Mr. Stewart, was that you had to apply the test at the moment of issue of the claim form. But until you know what's in dispute, how can you?
Quite. Well, my lord, that was in. Sorry.
So, I mean, that's before you get to common issues arising, because there may not be any dispute about whatever those questions might be.
My lord, I did make that submission. submission. I hope that what I was doing was in the context of where, in answer to my Lord the Master of the Rolls several times, I was saying the context of what one is seeking to look at the consequences. It would appear very strange that you're deciding whether or not, or effectively deciding who can be parties to a claim form at the point when it may be completely impossible to define or look at issues of commonality. Can I just draw your attention to what we say in paragraphs 19 and 20 of our skeleton argument, which is where the judge was critical of the fact that the claimants hadn't addressed how a sampling exercise might work, what the common issues were, and so forth. Well, those are the submissions that I wanted to make in relation to the point, the fourth heading that I was talking about at the beginning of this morning, which is why the construction adopted by the Divisional Court gives rise to unsatisfactory and unpredictable results. The fifth position is the pre-CPR position. I'm going to take this pretty briefly for two reasons.
I mean, we've read your skeleton, and we've looked at the CPR, and we've read Hannay, and we've seen how the matter developed in 1910, and then again in 1960 something, 65. Do we need any more than that?
No.
I mean, it was all jolly interesting. But the thing that I find more interesting, only because I was involved in it in the way I said earlier, is what actually happened in that 1980 onward period, and is it relevant? Because you both refer to the guide, which I remember being produced by Mr. Boucher and others, but I can't remember why it was produced.
Well, my Lord, we've referred directly to the Wolf report in the section where we've dealt with it. Our submission in relation to this part of the case is that there is no evidence of any intention to have a radical change or change indeed from the position which, as you say,
In Lord Wolf.
In Lord Wolf,
He doesn't mention.
well, he comments, and we've set out, I hope, the
Yes.
passage in our skeleton argument. But there is no evidence of an intention to change the position in, as set out in what had become 15.4, but which had really been in place, as your Lordship says, for 90 years or so, prior to that. The other point, just in terms of history in relation to all of this, your Lordship, when chasing me out of my first ditch, made the point that it would be a pretty radical swing to go from the position under the rules of the Supreme Court to the one which is in my skeleton argument. But the same can be put the other way in terms of the position now being set out in the rule. But to come back to your earlier question,
so you say that it's a remarkable liberalisation in the CPR without any heralding in the Wolf report.
Absolutely, absolutely. That's what I say. Now, my Lord, other than the representative actions, I have a few comments to make in relation to my learned friend's skeleton argument. This is not by reference to anything which is contained within the this is not by reference to anything contained within the ECHR, as I said previously.
Or the other part of the respondent's notice.
No, not really. My Lord, can I just take you to what he says at paragraphs 4 to 6? Well, indeed 7. Where there's some relatively extreme language used by my learned friend in the second sentence, particularly of paragraph 7. The underlying application of the appeal are cynical attempts to avoid liability if a duty is freely assumed and wantonly breached. The appellant well knows, because the respondents explained their position in evidence, that if the respondents are deprived of legitimate benefits of litigating as a group, the overwhelming majority would give up. They'd be unable to bear the cost burden, equally importantly, the relatively high and unaffordable costs and risks of unitary claims. Indeed, were the Court of Appeal to allow the appeal, the immediate result would be more than half the respondents' claims would be likely time barred, to be a wholly unmerited windfall for the applicants, and more particularly for its professional indemnity insurers. That is a slightly unfortunate, in my submission.
Is it true?
No.
Is it true that they'd be time barred now?
Yes.
They would be time barred.
Can I just?
In what respect is it untrue?
It is untrue in that we received 9 letters of claim in 2020 when they were well within time. We responded to those 9 letters of claim. This is all of the evidence which was before the judge.
Yeah.
We then received, out of the blue, a letter indicating that they intended to proceed by way of a single claim form in October of 2022, when they were still within time. We responded saying that we did not consider it was appropriate for them to issue a single claim form, and they chose to issue a single claim form in January of 2023. Now, that does not sit very well with the allegations of cynicism and so forth which are being put forward. They were told what our position was, rightly or wrongly. They were told before the limitation period
So
expired.
maybe they couldn't all afford £10,000.
My Lord, yes, but that may or may not be the case. But what cannot be, in my submission, fairly said by my learned friends in relation to...
Well, I don't think it's fair to criticise the language. He's making his point strongly. I think it's not helpful to do that.
Well, Lord, you understand why, from our
Yes,
point
well,
of
you
view-
say you told them so.
Well, we told them so in good time.
Yeah, no.
Well, that's the first point. The second point which is made is in paragraph 8. Such consequences run contrary to the liberal development of procedural law over the past century. Forcing everyone to issue a separate claim form will be ultimately futile. It's inevitable that all the respondents' cases would be consolidated and tried, at least in relation to common issues together, and the reference is to the investors' compensation scheme against West Bromwich, and we have that decision in tab 10 of the bundle, starting at page 141. The first point, obviously, is this case has nothing to do with the issue as to whether or not the bringing of a single claim form is permitted in relation to different causes of action. What happened in that case is that there was an equity release scheme which had been entered into by various elderly people on the advice of a financial advisor. The schemes caused them loss and damage. The advisor couldn't compensate them, so that fell to the ICS, and any other claims were assigned to the ICS. The judge had to decide whether the financial advisor was negligent, made misrepresentations, and also had to decide whether the solicitors retained by the claimants of the Building Society had been negligent. Page 145, the judge finds that the solicitor owed a duty to draw attention to the unusual roll-up provisions. At 148 to 149, pages 148 to 149, you see the...
What's this got to do with anything?
Well, my submission is nothing.
Well, shall we wait and hear what Mr. Johnson says it has? We'll come back at 2 o'clock.